The Federal Court of Appeal just handed a backhand to the face of the Canadian government. We have breaking news this morning, folks. Canada's top appellate court has shut down the government's appeal and confirmed that the Emergencies Act was invoked unlawfully and unconstitutionally during the Freedom Convoy. The court was explicit. Discretion does not override the law, and the legal thresholds were never met. This was not even close. Let's take a look. Ladies and gentlemen, this is the decision that was dropped at around 11 o'clock this morning. And this is just huge news in Canada today. This was brought forth by the Canadian Civil Liberties Association originally in the lower court, and it was brought forth against the Government of Canada. This is why you see Attorney General of Canada at the top. And as you may recall, in the lower court, they ruled that the Emergencies Act was unconstitutional, and 8 minutes after that decision came out, the Government of Canada announced that they were going to appeal it, and this is the result of that appeal. So, paragraph 8 in this decision, Federal Court of Appeal says, "For the reasons that follow, we are of the opinion that every appeal before this court should be dismissed. Every one. The federal court correctly determined that the declaration of a public order emergency was unreasonable and that parts of the regulations and economic order infringed paragraph 2B and section 8 of the Charter of Rights and Freedoms. We are satisfied that the paragraph 2B infringement sufficiently accounts for the related right to assemble under paragraph 2C and decline to address the cross appeal. As for the preliminary matters, the federal court made no reviewable error with regards to standing or in admitting evidence that was before the POEC." So, let's just go over what the whole point of the Federal Court of Appeals is. The Federal Court of Appeals is not there to retry the entire case. That's not what happened here. In the lower court, what happens is you bring forth your case, the defendant comes in and you file your evidence, and then the case is tried, where witnesses come in, you present your evidence, witnesses testify, there's cross-examination, and then after all of that, the judge makes a decision, puts out a ruling, and there we are. When it gets to the Federal Court of Appeal, their primary job is not to look at the evidence, but their primary job is to look at how the judge in the lower court applied the law. They're reviewing if the law was applied correctly. Now, if you're curious about the main points of the lower court's decision, you can take a look at a video that you'll be able to click on at the end of this video. We did one after that decision came out, and we walked through it. And that was Judge Mosley, who was a Trudeau-appointed judge. So let's give credit where credit is due, that judge put partisanship aside, put politics aside, and applied the law in the spirit that it should be applied. So this is what the Federal Court of Appeal's job is to do. And there was 3 judges at the Federal Court of Appeal, and they evaluate this. So it's 3 times the expertise that is supposed to be looking at this. And they wrote this almost 200-page long decision, and they reviewed all of the arguments that Judge Mosley made in his decision, and they found no problems with it at all. And what we're going to do is we're going to go through some of the highlights of their decision where they make their own points. They refer to Judge Mosley's points because they were so sound. And then we'll conclude with what happens next. So this is paragraph 79. Ultimately, the federal court stated its conclusion with respect to the existence of a national emergency in the following paragraphs. So they're referring to Judge Mosley's decision here. So in Judge Mosley's decision, paragraph 253, due to its nature and to the broad powers it grants the federal executive, the Emergencies Act is a tool of last resort. The government in council, aka the Prime Minister, cannot invoke the Emergencies Act because it is convenient or because it may work better than other tools at their disposal or available to the provinces. This does not mean that every tool has to be used and tried to determine that the situation exceeded the capacity or authority of the provinces. And in this instance, the evidence is clear that the majority of the provinces were able to deal with the situation using other federal law, such as the criminal code and their own legislation. So all that's basically saying there is, listen, you didn't need the Emergencies Act, and it was demonstrated that the provinces didn't need the Emergencies Act to handle the situation. 254. The Section 58 explanation concludes that the ongoing protests had, quote, created a critical, urgent, temporary situation that is national in scope and cannot effectively be dealt with under any other law in Canada, end quote. That was one of the arguments that the government made during the original trial. While I agree that the evidence supports the conclusion that the situation was critical and required an urgent resolution by governments, the evidence, in my view, does not support the conclusion that it could not have been effectively dealt with under other laws of Canada, as it was in Alberta, or that it exceeded the capacity or authority of a province to deal with it. That was demonstrated not to be the case in Quebec and other provinces and territories, including Ontario, except in Ottawa. Paragraph 255. For these reasons, I conclude that there was no national emergency justifying the invocation of the Emergencies Act, and the decision to do so was therefore unreasonable and ultra-virus. Paragraph 84. While the federal court agreed that the events at the time were concerning, as we just talked about, it was not satisfied that the evidence disclosed an objective basis based on compelling and credible information for the GIC's belief that there were threats or use of serious violence to persons or property. Reports of violent incidents and threats of violence and arrest were quote-unquote vague and unspecified. The weapon seizure at Coutts remained the sole act or threat of serious violence, and it had been dealt with by the RCMP under the authority of the Criminal Code. And despite what you may agree or disagree with, that is the case. They didn't need the Emergencies Act to deal with what happened at Coutts. So that is a false narrative if you're hearing that out there, that the Emergencies Act was necessary because of what the beliefs were having at Coutts. The proclamation's fifth ground for invoking the Emergencies Act referred to the potential for an increase in the level of unrest and violence. Yet, except for the situation in Ottawa, the record did not indicate that local police were unable to deal with the protests. Paragraph 86. In its view, while the harm to Canada's economy, trade, and commerce was very real and concerning, it did not constitute threats or the use of serious violence to persons or property. We covered this in our original video as well. This is the biggest problem for the government because in the Emergencies Act itself, it says that you can only invoke it if there is a national emergency and also a threat, a credible threat to national security. Now that threat is actually defined in something called the CSIS Act, and we talk about this in that other video. And economic threat is not defined in the CSIS Act at all. So the government cannot use economic threat as a justification to invoke the Emergencies Act. This is what the court is saying. This is what the lower court is saying, and this is what the Federal Court of Appeals is saying. They're saying absolutely. It wasn't justified because it did not meet the threshold required in law of what you need in order to invoke the Emergencies Act. Cut and dry. Paragraph 88. With respect to paragraph 2B of the Charter, the federal court found the regulations were overbroad to the extent that they criminalized the entire protest and limited the right to expression of protesters who wanted to convey dissatisfaction with government policies. Accordingly, it determined that the freedom of expression of peaceful protesters who did not participate in the actions of those disrupting the peace was infringed. That paragraph right there by the Federal Court of Appeals is a very important one because there's a narrative going around online right now that the Freedom Convoy was trying to overthrow the government. And this was a similar narrative going around legacy media at the time. But the Federal Court of Appeal doesn't agree with that narrative. So for anyone that is trumpeting this online, point them to this. That's not the conservatives. That's not some conservative MAGA maple people. What this is a objective decision by 3 different judges who were involved in writing this. And they're saying that this was a peaceful protest. Case closed. Otherwise, they would have said, well, This was a angry, violent mob in Ottawa, and they were trying to overthrow the government. And therefore, the Emergencies Act was justified because it was a threat to our national security, because they were trying to overthrow the government of Canada. That's what would have happened if they actually believed that these folks were intent on a coup and overthrowing the government. But that's not what they said. And that's not the decision that the lower court came to, and that's not the decision that the federal court came to. So for anyone saying that, point them to this. Paragraph 93, the federal court found that the search and seizures, and this is related to the bank accounts, were not reasonable for the purpose of Section 8 of the Charter because the economic order failed to require reasonable grounds before a search was conducted. The RCMP superintendent who oversaw the implementation of the economic order confirmed on cross-examination that the RCMP required only bare belief before freezing accounts and accessing the underlying financial information. For the federal court, this failure to require some objective standard breached Section 8. And people wonder why Canadians are mistrustful of the RCMP. CBC wonders why. CTV wonders why. The legacy media wonders why people are mistrustful of the RCMP and calling their leadership corrupt. So basically what happened is Trudeau and Freeland went to the RCMP, based on what this is saying, and they said, hey guys, we need you to seize all these bank accounts because we believe they're an economic threat. Oh, you believe they're an economic threat? Yeah. Okay, well, that's good enough for me. Rather than saying, hold on there, Skippy. What do you mean economic threat? You're going to have to provide me some sort of objective evidence that you need to do this. You're going to provide me a sound argument, something, rather than just what you scribbled on a napkin. Because otherwise I'm not doing it. But they didn't do that. They just said, yes, sir, thank you, sir. I serve at the pleasure of the Prime Minister, and this is the problem. Conclusion. In light of the above reasons, of which there are over 500 of them, we are of the opinion that the appeals by the Attorney General of Canada in all of the files should be dismissed, as should the cross appeals by the CCLA and CCF. Since neither the Attorney General of Canada nor the public interest litigants have requested costs, none will be awarded. So what they just said there is all three judges came to a consensus and said, this is clean. There is no reason for us to look at this. Everything's dismissed. And in terms of costs, when you're in this situation, you could ask for legal costs to be awarded back if you win, but that wasn't asked for in this case. So this is where we are. The Federal Court of Appeal just handed a backhand to the face of the Canadian government for appealing the decision in the lower court that the Emergencies Act was unconstitutionally invoked. And this wasn't close. They didn't talk about anything that I found where there were dissenting opinions. Well, maybe Mosley missed this, maybe Mosley missed that. No, we talk about in our previous video that Mosley laid out a very long, detailed, and careful argument as to his decision. And the Federal Court of Appeal laid out an equally long and detailed opinion on why Justice Mosley was right. So what happens now? Now, this could be appealed by the Government of Canada and brought to the Supreme Court of Canada, and then that's the last step. But the Supreme Court of Canada may not hear it. And they may not wish to hear it because, again, just like the Federal Court of Appeal, their job is to review, was the law applied correctly? So given that there was no dissenting opinion, and this wasn't close at the Federal Court of Appeal, in terms of their interpretation of if the lower court applied the law correctly, the Supreme Court of Canada may say, you know what? Why? Why would we even look at this? There was no dissenting judge. All three of them agreed. There didn't seem to be any issues with any of the things that Mosley argued. And it seems like they agreed that he applied the law correctly across the board. Why would we even look at this? But who knows? They may choose to hear it just so the government can't say, well, the Supreme Court refused to hear this. But pending the outcome of that, the question Canadians have is, can anybody be charged in the government or that were in the government when this was actually invoked? And unfortunately, our laws don't allow for that. I believe that they should. I believe that the laws should say in the Emergency Act itself that if they invoke it and the courts determine that it was invoked unlawfully and it violated people's rights, I think they should go to jail. And if that's something you believe, talk to your MP, write a letter to your MP, and let them know that I want that in there. But that doesn't mean that there is no recourse whatsoever. We were at an event last night with Larry Brock and Ned Curick, our MP, and this question actually came up. And what Mr. Brock had said was that, listen, there may be, after this is all said and done, there may be a civil class action suit that could be brought by folks against some of the people that were involved in this, or maybe you can bring it against the government of Canada yourself. I'm not a legal expert, but for the folks that were impacted by the invocation of the Emergencies Act, for the folks that had their rights trampled during the Emergencies Act, you might have a civil recourse available to you. So if you're interested in that, I would consult counsel. You may want to talk to some folks at the JCCF or the Canadian Constitution Foundation or any of these other civil liberties associations. Get some advice before you make any decisions and see what they have to say, because you may be able to get some sort of recompense for that. And it's a lot better than nothing. But until then, this is a huge win for the folks who are the Freedom Convoy. It justifies what they were trying to do at the time, and it just further indicts the fact that we may have had the most corrupt and power-hungry government of all time, but Mr. Carney's government seems to be trying to give Justin Trudeau a run for his money.